Paul Garver with Hawbecker and Garver here, and I am talking today about the inspections and additional inspections paragraphs on pages 5 and 6 of the contract. We are going to start this discussion, though, by reviewing back and taking a look. I know this was talked about in a prior video, but page 2, lines 65 and 66 of the contract. It's going to be paragraph 7, page 2, line 65. And we can see here what it says. It says, a seller warrants to buyer that all fixtures, systems, and personal property included in this contract shall be in operating condition, except, right? And that's what we got there at line 65 and 66. So that's an interesting line. And I think it's important to talk about what that means really quick. So in a normal deal, a deal that is just typical, we're not talking about an as-is condition deal. We're just talking about a straight deal. What this contract says is that the seller says that all fixtures, systems, and personal property shall be in operating condition at possession. And that's normally closing, although if there is post-closing possession in a contract where a seller remains in the property post the actual closing for a time, kind of renting back the property from the buyers, that this does mean whenever they do turn over possession that these things will be in operating condition at that time. So it's important to think about this. I think using some real world examples is a good way to illustrate it. So if your buyer puts an offer on a home and it's a normal property, a normal contract, not an as-is condition contract, but a normal contract, and that buyer goes and does their inspection, and they find in the inspection that the HVAC is not working. Or let's say they even miss that the HVAC is not working. So it's not working, but they don't know that. And they don't ask for it to be fixed during their inspection period or their attorney review period. We get to closing, and the buyer goes and does their final walkthrough. And at that point in time, they notice that the HVAC isn't working. Well, it's a walkthrough issue. And I know that's going to be a little bit of shock to some people because they're going to say, but wait a second, they had an opportunity to do their inspection and they didn't ask for it. Well, that's okay because the seller is warranting right here. They're giving a warranty. It's almost as if it's a piece of paper. It's a warranty saying, we're going to make sure these things are in operating condition. In fact, it is a piece of paper. It's on the contract. But they're saying we're going to have all of this stuff in operating condition at possession. So since they're going to have all that stuff in operating condition at possession, it's going to be an issue. Now, that's not the normal practice. The truth of the matter is that normally when a buyer finds something like that not working during their inspection, they bring it up. Why? Because they don't want to get to closing and have a big issue that everybody fights about, and we have to cause problems, and it takes hours and hours to resolve. We all want closings to go smoothly. Boring closings is really what everybody is after. Right? So that's the reason why we don't see it happen that way very often. But in reality, this is what the contract says and states. Okay. Now, we're going to move now to the inspection pages of the contract. And what I'm going to attempt to do here is give us a view that is maybe more than one page side by side. And here we go. We have 2 pages side by side now. But I'm going to zoom it in a little bit. So here we are. We have the inspection paragraphs, and on pages 5 and pages 6 of the contract, and we're going to start here at paragraph 14. And what we have at paragraph 14 is the as-is condition paragraph. But what you can see here between paragraph 14 and then going all the way to paragraph 16, these are all kind of the inspection related paragraphs, right? The things that they are all grouped together in the contract. So we start with the as-is condition paragraph. And what this paragraph says is, and we're going to read it together, it says, no representations or warranties of the physical condition of the real estate. Great. And we initial if this is applicable. It's not automatically applicable in the contract. It does say this contract is for the sale and purchase of the real estate in its as-is condition as of the date of offer. So now that's different than what we just talked about under paragraph 7. We were talking about the date of possession in paragraph 7. What this says is, hey, the buyer is taking the property in the condition that it was on the date of offer, which is very close to the date of acceptance and also usually very close to the date of inspection, right? So that's the condition that the buyer is saying, I'm taking the property in that condition, right? Or really the seller is saying to the buyer, I'm going to leave you the property in this condition. So let's go back to our example. If the HVAC was not working on the date of offer, when the buyer goes and does their inspection, well, if it's not working on the date of possession, that's okay. It's not a walkthrough issue because that's what the contract says. And it actually further goes on to say if you look at line 192 to 193, buyer acknowledges that the warranty provisions of paragraph 7 as set forth on lines 65 to 66 do not apply to this contract. So there you go. We deleted that sentence that said, hey, everything's going to be working on the time of possession. And what we're saying is now, hey, whatever was working on the date of offer will be working on the date of possession, right? The contract is for the sale and purchase of the real estate, and it's as is condition as of the date of offer. So that is the biggest first difference between an as-is contract or an as-is condition contract and a normal contract. Now we go, the next line, 190, buyer acknowledges that no representations, warranties, or guarantees with respect to the condition of the real estate have been made by seller or seller's designated agent other than those known defects, if any, disclosed by seller, except for those representations made in paragraph 24. So what does this mean? Well, this means buyer can't rely upon anything except the representations and warranties in the four corners of the contract and the things that they had to disclose via statute. So very simply, they can't rely upon any emails from agents or sellers or love letters between the clients. That's what sometimes we call those letters that get exchanged between buyers and sellers as inducements to buy or sell. And so you can't pull those in. You can't pull in other documents, other emails, other texts, things of that nature. Really, the only thing we can rely upon is the contract. So that is really the essence of as-is condition in this contract. We move on, and there is that last line here that says, buyer at 193, buyer waives any inspection unless paragraph 15B or 15C is initialed. So let's get into that, right? We get to the inspection paragraph, and it is absolutely imperative if you're a buyer or a buyer's agent that if you want to have an inspection, you actually have to initial off on one of these paragraphs. It's a little bit new under this version of the contract. You actually have to make a choice. I like to say this is the choose your own adventure portion of the contract, where you get to choose the adventure that you as the buyer and your agent, that you guys are going to be taking together, right? And that either starts with three options. Either you're going to, at 197, waive the right to have any inspection, or at 200, paragraph B, subparagraph B, right? It says right to inspection with requests. So that very simply means you get to do an inspection, and if there are things that are not in operating condition, then you get to request for those things to be repaired. And then at 234, paragraph C, the right to inspection with no requests. Pretty easy. I do want to point out line 196. It's in bold and in caps, but sometimes it's easy for people to miss. If no subparagraph is initialed under this section, subparagraph A shall apply. So that is you are now waiving your inspection if you don't make any choice here. And that's definitely might not be what you want to do, right? I actually don't suggest the clients to waive inspections. But so if you choose to waive an inspection, fine. Initial off so that it's very clear to everybody, subparagraph A. But if you are going, if you want to have an inspection, whether it be with requests or without requests, make sure you initial off on the appropriate subparagraph. When we get to right to inspection with requests, it really says that you can conduct any inspections that you might want to. And you can see it here. It says at 202, 203, real estate by one or more licensed or certified inspection services, home, radon, environmental, lead-based paint, wood destroying insects, all those inspections. But at 203, it says, or any other inspections desired by buyer in the exercise of reasonable due diligence. So, we do see people do sewer scopes. We see people do all sorts of inspections. You might see mold inspections. You might see lead inspections. You might see things of those nature. And those have all been considered to be in the exercise of reasonable due diligence. So, and it does also say that the seller will make the real estate available and accessible, right, for the inspections to happen, and to make sure that all the utilities are turned on at the time of inspection so that they're not off, because otherwise we can't tell if things are in working condition, right? And it does say at line 205, 206, buyer shall indemnify seller and hold seller harmless from and against any loss or damage caused by any acts of buyer or any person performing any inspection on behalf of buyer. So if your inspector or you damage property, it's going to be on you, buyer, and to make that right for the seller. All right, so we do have the requests for repairs, and you can see this at line 208, are going to cover only the major components of the real estate, and it lists out all those major components, right? And then when we get to line 210, we're going to see a major component shall be deemed to be in operating condition and therefore not defective within the meaning of this paragraph if it does not constitute a threat to health or safety and performs a function for which it's intended, regardless of age, or if it's at the end of its useful life. Minor repairs, routine maintenance items, and painting, decorating, or other items of cosmetic nature, no matter the cost to remedy the same, do not constitute defects. And you can see right there in bold at 215, a request by buyer for credits or repairs in violation of the terms of this subparagraph shall allow seller to declare this contract terminated and direct a return of buyer's earnest money. So very simply, buyer, if you are a buyer and you end up asking for something, and definitely definitions can vary between attorneys, but if you are going to be asking for things that your seller may deem outside of the contingency, just be prepared that your seller may come back and cancel on you. I mean, if that's not what you want, you probably need to be a little bit careful on what it is that you're requesting, right? And then it goes on, by the way, to say that if you kill the contract, or if you serve and ask for inspection requests, that you do not send the inspection report to the seller unless the seller requests that. So if you want to send the inspection report to your seller, you got to get the seller's permission first and discuss that with them. And usually the attorneys or the agents will handle that. Then we get to this paragraph C as well, by the way, the subparagraph C 234 now is what we're talking about. And this is a right to inspection with no requests, right? Very simply, the essence of this paragraph is right at line 237. In the event that the inspection, reveals that the condition of the real estate is unacceptable to the buyer, and buyer so notifies seller within 5 business days after the date of acceptance, this contract shall remain null and void, or shall be null and void. Buyer shall not send any portion of the inspection report with the notice provided under the subparagraph unless such an inspection report or any part thereof is specifically requested. So the exact same thing that we talked about in the right to an inspection with requests, you can't send the inspection report. So you don't think you're going to send that. But what you get to do is you get to do an inspection of the property and then say, either I'm in or I'm out. I'm going to proceed, or I find the property unacceptable and I'm declaring the contract null and void. And very simply, we need to read the last line of this paragraph to really get its essence, right? A request by buyer for credits or repairs in violation of the terms of this subparagraph shall allow seller to declare this contract terminated and to direct a return of buyer's earnest money. So very clearly, if you request anything, your seller is going to be able to cancel on you. So what's proper to do under this paragraph? If you're a buyer and you find something that happens sometimes, maybe it's high radon, maybe it's something else, and you're not going to be willing, you got to make a choice. You got to say, I'm not willing to move forward on this unless you do this. And I think really very simply what you can say is, we find the property unacceptable, which is exactly what the paragraph says that you can do, right? And therefore, that means that you're terminating the contract, right? So we find the property unacceptable, but we're willing to move forward if you do X, and maybe X is radon or mold or whatever it might be, right? But those are the types of things that I think you can do under this paragraph legally. You have the right to terminate, and you always have the right to counteroffer if you terminate. So that's contract law. You can't really prevent someone from doing that, right? But you don't have the right to try to request something and expect that you're going to be able to stay in the contract. and move forward. You just want to see if the seller is going to be willing to do this. So be aware of that and take that seriously, and make sure that when you're making requests, you do it in the proper way to keep yourself in line with the contract legally. When we get to paragraph 16 here, you can see additional inspections not subject to paragraph 14 and 15. So if these are initialed off on, and let's say that you waived your professional inspection under paragraph 15, that doesn't get rid of these. These still happen. These still go. And 16A is very simply the wood destroying insect inspection, what people often call the termite inspection. And it says that within 15 days after the date of acceptance, seller at seller's expense shall deliver to buyer a written report, right, stating that there's no visible evidence of active infestation by termites or any other wood destroying insects. So you have that, right? If you get it and it discloses evidence, buyer has the option for 5 business days after receipt to either proceed with the purchase or declare it null and void. Again, I think that your right here is to say, hey, we're declaring this null and void, but if you're willing to do X, Y, or Z, we're willing to move forward. Just be sure that when you say that, you really mean it, because so you can't, when you declare something null and void, it's very difficult to take it back if you can even. Then we get to the well and sanitary inspection paragraph here. And what we see is a paragraph that says, hey, if there is a well or sanitary inspection, seller is going to get inspections of that well water test, making sure that it has an adequate gallons per minute that goes through, and making sure that there's a bacteria and nitrate test. And then they're going to get a septic report from the applicable county health department, a licensed environmental health practitioner, or a licensed private sewage system installation contractor. There's only certain people under law that are allowed to conduct these types of inspections of septic systems, and that's who we have in there, right? And it's supposed to be dated not more than 90 days prior to closing, and it's going to state that it's an operating condition. If there are defects noted, it says that the seller has to make these repairs to include landscaping up to $5,000. If the repairs exceed $5,000 to include the landscaping, then the seller has the option to terminate the contract. And usually what you see is maybe some potential negotiating happening at that point in time. So there we have it. It does say additional testing, and we're at line 261 now. Additional testing recommended by the report shall be attained at seller's expense. If the report recommends additional testing after closing, the party shall have the option of establishing an escrow with a mutual cost allocation for necessary repairs or replacements, or either party may terminate the contract prior to closing. Seller shall deliver a copy of such evaluations to buyer not less than 10 business days prior to closing. So if you get in a situation here where seller hasn't gotten you the stuff until very close to closing, and it says things need to happen and they don't have time to make these repairs before closing, you have the option to kill the contract as the buyer, or you have the option of putting some money into escrow that you can mutually agree upon. I hope this was helpful for all of you. I really appreciate you guys taking the time to watch. We wanted to keep it short so that you could watch these things in spurts, but hopefully it's still packed with some information for you. Take care and have a good day. And if you have any questions, don't ever hesitate to call.